Ontario court unconvinced that Sharia laws precluded mother's fair hearing in Kuwait. This was decided in a recent Ontario court case. The parents had married in Kuwait in 2008 but separated in 2018. After an altercation involving physical and verbal abuse that was witnessed by their 3 children, the police were called. The father moved out that same day and obtained an order from the Kuwait court giving him 12 hours of access each Friday. The mother countered by commencing proceedings for custody and alimony in keeping with Kuwaiti family law. Shortly after, without telling the father, the mother took the matters into her own hands by leaving Kuwait with the children using US visas. Upon arriving in Canada, she made claims for refugee status based on what she alleged was the father's abusive conduct towards the children. She claimed that not having contact with him would prevent the risk of serious harm, and contended that it was in the best interest of the children not to return to Kuwait. She also claimed that the legal system in that country did not protect women and children from domestic violence. The father applied to the Ontario court for an order requiring the children to be returned to Kuwait. The key question was whether the court had jurisdiction to make an order concerning the children's custody and access in these circumstances. The Ontario court ruled that it did not. After examining numerous issues, it ordered that the children were to be sent back to Kuwait. The court noted its authority over these children was already tenuous at best. Kuwait was not a signatory to the Hague Convention. The court's authority, if any, was found in the provisions of the Provincial Children's Law Reform Act. That legislation offered the court only very limited jurisdiction in cases like this one, where the children's habitual residence was not in Ontario. The mother had not met the evidentiary burden to prove that they were at risk of serious harm if returned to Kuwait. The court rejected the mother's notion that Kuwaiti family law does not protect women and children after hearing evidence tendered by a court-qualified expert in Sharia law. The court also found that many other aspects of the mother's claim were suspect. She was not credible. She gave inconsistent, exaggerated, evasive, and contradictory testimony, and omitted important details that did not serve her narrative. The court also noted that while the eldest child wanted to stay in Canada, this was not sufficient to tip the scales in favor of having all of the children remain here. The children were ordered to return to that country with the father booking and paying for all their travels, which were to take place in the mother's care. If you like this video, please share it, comment below. You can leave any questions that you have, and we'll try to answer all those questions at the end of each week. Thank you for watching today, and I'm Russell Alexander.